Again, I think this is a very interesting factual and legal case, and to help me break this down, we have Jeffrey Simon and Megan Whiteside, both of whom are trial attorneys. Thanks for being on the show, guys. In studio, we have Jeffrey. So, Jeffrey, I'm going to go to you first on this. Before we were talking, and before the clip was being played, it was your opinion that this involuntary manslaughter may be a difficult charge. And when I ask you what that means, I think that there's a sentimentality out there by a lot of people that where's the causation? I mean, where do we go where we're going to hold people accountable for the actions of other folks? Does that tie into your assessment?
Exactly. Involuntary manslaughter is criminal negligent homicide without malice or premeditation. I think it's pretty easy to say the parent shouldn't have given this young man a gun. Mm-hmm. There was something tormented about it. But the evidence, at least so far as established in what we looked at, is the school did not perceive Ethan Crumbley as a violent threat, just as an emotionally unwell person who needed treatment. They didn't discipline him. They didn't search his backpack. To then argue that the parent should have put all this together beyond a reasonable doubt, I think is a tall order.
Yeah, Megan, what are your overall thoughts on that? And to the point, and I think we may see this in a clip, then we go down a little bit down the road on cross-examination. As a defense lawyer, you want to bring out exactly what Jeffrey is saying. It's like, if this was such a danger, this is a person that you should have known and you should have been more proactive with. So how can you then hold the parents accountable? Does that wash with you?
I'm going to play devil's advocate here. I think that what a school administrator, even a dean of students who should know what's going on with students, this is a large school, and to hold an administrator or an educator to the same standard as a parent who is spending day in and day out with their child, if there is evidence that they willfully ignored his mental health crises or some danger that they should have been aware of, and in combination gave him unfettered access to weapons, I agree with the both of you. This is a novel theory, and it's really going to depend on the evidence. But I don't think you can hold a parent to the same standard as an educator. The parents are the ones that are with their child, know their child, or should know their child better than anyone else.
Megan, I want to flip this back to you in light of the devil's advocate position, which I appreciate. It's important here because there's not a clear-cut path on this case. But one thing I think this defense attorney was trying to do was to show, obviously, the danger quotient wasn't there. We discussed that before. Later in the cross-examination, the defense attorney did a very effective job at explaining the gun culture at that school, that the people are constantly drawing pictures of guns on homework assignments. They go hunting prior to going to actual class, that they're told, just don't bring your gun with you to school after you go hunting, that you could see pictures of women and boys in prom outfits with guns, you know, in their dresses and gowns and things of that nature. So we're looking at a little diagram of what the dean is saying is often found on homework assignments and things of that nature at the school. So is what the defense lawyer doing here is making a connection that, look, gun culture and guns in this particular area are a lot different than they are in places like New York and New Jersey. It's a lot more liberal in terms of having them. And in this particular case, you still have to show causation, right? In a criminal charge, sorry for the long question, in a criminal charge, in involuntary manslaughter, typically speaking, it's not just that you should have known, it's like there's a substantial likelihood that you would know that your actions or inactions would cause this result. Last point, many people are mentally ill, many people are emotionally not right, and they have weapons, but they wouldn't go and kill people. Is it reasonable to expect these parents would have?
So that's the question, right? And the government is going to have to show that these parents individually willfully ignored the signs that their son was a danger to society. And that's a really tough burden to cross. That's a tough burden to prove. And so the culture at the school and what kids in that community were doing absolutely goes to the foreseeability argument, what you're talking about, proving that causation, that they knew or should have known that their son was a threat. And so if this culture normalizes from hunting to drawing guns and anything in between, that cuts against the government's argument that there was something unusual here, that there was that gross negligence, that willful ignorance, putting your head in the sand when you knew your son was a threat and giving him unfettered access to weapons. So I think that the cross-examination here has been effective. And it's highlighting that this novel legal theory is going to be tough to meet.
Yeah, Jeffrey, so let's drill down on that a little bit, because that is exactly the point that I'm trying to raise out. And I know the audience may be either confused or agitated about what I'm about to say, but there's a difference between an unfortunate and regrettable, horrible, we wish it never happened accident versus criminalizing conduct. And that's why, at least in my state, and it could be, obviously each state's different, but the laws are typically the same. It's not just that you knew or should have known. There's got to be a conscious disregard that your inaction, a reasonable person would have known would cause this result. That's a really hard standard here. What are your thoughts about the cross-examination in terms of at least my assessment of the law?
I agree with your assessment, and I agree with Megan's assessment. This cross-examination's been very effective. That was a very important admission. You, the school, did not perceive Ethan Crumbley to be a violent threat. Therefore, how could the parents? In fact, you had information, red flags, violent ideations, drawings, ordering or looking to order bullets online, but you, the school, didn't conclude that that was going to make him violent or that it was indicative of a tendency towards violence, and you didn't report all those things to the parents in real time.
Well, I was just about to ask you, and obviously you got more information on that, because I was going to say, was that information from the school communicated to the parents? Because we know we're living in a society where more and more what's going on in the school, who stands in locus parentis, in other words, in the place of the parents, for some reason is not being communicated to the parents. So that may be a very, very big fact if the defense can show that the parents were not apprised of those things. I guess we'll have to wait and see.